I'm going to talk to you about discrimination in the workplace. Until the 1970s, employers were free to recruit employees with few, if any, legal restrictions upon how much those employees had to be paid and other terms and conditions of employment. How things have changed in the last 30 years. Due to subsequent interventionist employment legislation, much of it deriving from the European Union, the concept of freedom of contract in terms of employment relationships has been blown out of the water. This has been the case in many respects, including the whole minefield of minimum wage legislation. Particularly controversial, though, has been the development of anti-discrimination laws, which I'm going to talk about, but very much in outline. In summary, it's unlawful for an employer to discriminate against, victimize or harass an employee or potential employee upon the basis of any of the following: gender, marital status, nationality or race, disability, part-time working hours, religion or beliefs, sexuality, transgender status, and also their age, or it will generally be fairly obvious where there has been direct or discrimination or indirect discrimination based upon a person's sex, racial origins, for example, an employee being denied promotion due to their sex or being subjected to racial or homophobic abuse in their workplace. You can, however, also face possible claims for indirect discrimination, it being possible for such a claim to be brought by an employee falling into most of the categories I've just listed. Indirect discrimination will often be more difficult to spot. This could include, for example, firstly, requirements relating to working hours, which might be more of a bar for women than men due to childcare commitments. Secondly, a policy requiring male employees to be clean-shaven or without headwear, which could put Sikhs in general at a disadvantage. Thirdly, requiring employees to undergo testing to establish a certain level of fitness, when this could be likely to be seen to be put older employees at a disadvantage. Generally speaking, if facing a claim, the employer will have to prove that they did not discriminate against the claimant employee, meaning that they will have to prove a negative. Unlike other types of employment tribunal claims, for example, unfair dismissal claims, there is no upper limit on the amount of damages that can be awarded in respect of a discrimination-based claim. Awards running into 6 or even 7-figure sums are not unknown, including significant awards for lost earnings and hurt feelings. There are a number of ways you can reduce the risk. Introduce an effective anti-discrimination policy and ensure that it is widely publicised amongst employees and explain to them, making it clear that breach of that policy, if established, will result in disciplinary action. A solicitor will be able to assist you in drawing up such a policy at a realistic cost, which you will be able to agree with them. Ensure that you operate an open door policy where employees are always able to access their supervisor or manager about any concerns which they may have in respect of their employment. Act promptly and proactively upon becoming aware of any situation which may give rise to a claim. Consider obtaining a before-the-event insurance policy which in return for the payment of an often modest annual premium will cover your legal costs and provide for advice at an early stage if an employee does ever bring a claim against you. It can cost thousands of pounds to fight off a claim, whatever its merit, so take out insurance. To bring an unfair dismissal claim, it is ordinarily necessary to have been employed for at least 12 months. If, however, an employee alleges that the reason for their dismissal was discriminatory in nature, this 12-month qualifying period does not apply. Always consider taking immediate legal advice wherever an employee raises a grievance or circumstances arise which may result in a potential claim. Thank you for listening.